number of you, a third or so of you, know a lot about this particular project. Probably another third of you know something about it, and another third of you don't know much about it at all. And so I'm going to be working with the 1/3 that don't know much about it and work our way back up to where we all are familiar with this. But the bottom line is, what is it that this is all about? What this is all about is attempting to get an ordinance passed here in the city of Santa Cruz and in the county of Santa Cruz. An ordinance which, in fact, conditions the future employment of any employee of the city with regard to the city ordinance and with regard to the county, regarding the county ordinance, making it a condition of their future employment that they notify the city council or the county board, the county board of supervisors, the instant that they get any information whatsoever indicating that federal law enforcement authorities or military authorities intend to come into the county or city and attempt to take into custody any person and deprive them of their fundamental constitutional rights by basically renditioning them and dragging them into a military prison and holding them indefinitely with no notice to their family, no right to make any telephone calls, no right to have any attorney, and to be held completely indefinitely without any criminal charges being filed against them, and to hold them until the executive branch decides that the threat of terrorism against the United States has been eliminated, which could give you some idea how long that's going to last. That's basically what it is we're doing. We're trying to enlist you to participate with us, to engage in the various type of tactical steps that need to be taken in order to get these ordinances passed. And we'll focus on the one at the City Council first, because that's the first step. And if we can get the ordinance passed by the City Council, we'll then move to the County Board of Supervisors. And once we get the County Board of Supervisors on board, we will then move to other counties and try to get other cities and counties on board to the point where we eventually have the state of California being a constitutional protection zone in which the federal military and law enforcement authorities are not allowed to take anyone into custody and subject them to this draconian, unconstitutional procedure. Now, for anyone who may be concerned that that's a far reach to be able to get the entire state of California to take a position like this, I want to direct your attention to a statute that was passed by the House of Representatives, basically, in the state assembly. The state assembly passed a statute in February of 2013. This was about 1 year after Barack Obama signed into law the National Defense Authorization Act of 2012. That's the issue that we're dealing with here. What this ordinance that we're asking to get passed is all about is attempting to neutralize this federal statute that's been passed. And the federal statute was recommended by the extreme right wing of the Republican Party to authorize the United States military to arrest American citizens or anyone else inside the continental United States and hold them in military prison indefinitely, with no criminal charges filed against them, with no right to have a hearing in front of any judicial official to determine whether or not there was any probable cause to believe that they had committed any unlawful act at all. And people find this impossible, almost impossible to believe that this could happen. But the fact of the matter is that the statute that was passed by the Congress, because the conservative elements in the National Republican Party, when they were confronted by the extreme right-wing reactionaries that are in the Congress now, with this proposed statute, threatening to arrest and put into prison anybody who was determined by the executive branch to have given any type of significant support to any organization that the executive branch designated as basically harboring hostile intentions toward the United States government or any of our allies. That no one could quite believe when the right wing proposed such a statute that anybody would seriously consider passing such an act that was so broad and sweeping and so violative of the fundamental constitutional rights of citizens, the due process of law, that we, when we first heard about this, people kind of laughed at it. But what happened is that the conservatives in the Republican Party didn't want to be shown up by the extreme right wing to make it look like they were soft on terrorism by opposing a statute like that. So the conservatives in the Republican Party got on board, and so the entire Republican Party supported this statute in the House of Representatives. And then the moderate Democrats in the House, fearing that they would be characterized as being soft on terrorism, got on board, the so-called blue dog Democrats. And then the moderates in the Democratic Party, the other moderates, all came on board since they didn't want to look like the people that were opposing this. And ultimately, it was passed by the House of Representatives, 227 votes, all Republicans to start with, and then additional Democrats got on board, with 95 Democratic votes agreeing with them in the House of Representatives. In that then it went to the Senate, and people said, well, you don't have to worry about, the crazy right-wing Republican-dominated House of Representatives does all kinds of things, but the Senate's not going to let them do it because the Senate at that time was under the control of Democrats, and they ended up passing it and saying, well, Obama's never going to sign that. He won't sign that, and Obama did. On New Year's Eve, actually, of 2011, at 11:35 at night, on New Year's Eve, when everyone else is jumping up and down in Times Square watching the ball come down, he ends up signing into law this statute. And what the statute says is it says, this statute is designed to affirm the authority of the President to use all necessary and appropriate force pursuant to the authorization for the use of military force, including the authority of the armed services of the United States to arrest and detain covered persons as identified below in Section B. And then in Section B it says, a covered person under this section is any person who, and then they go through different categories under this. And this is how they always do it. They always start out by saying, well, the first category of people are all the rotten, terrible terrorists who kill people and cut their throats and cut their heads off, and so everybody's crazy about them. And then they kind of add additional groups, and they kind of go into a broader and broader area. And finally, they end up saying that a covered person is any person who substantially supports Al-Qaeda, the Taliban, or any associated forces who have engaged in hostilities against the United States or any of their coalition partners, including any individual person who has committed any belligerent act or who themselves have directly supported any of such organizations. And that's what it says. So that it's not only these terrorists, but it's also anybody who has given any kind of support to an organization that is deemed to be affiliated with them, and any person who has given any support to such an affiliated group, any person who has given any support to such an individual person is also subject to immediate arrest and detention. And so right away, people said, of course, what does substantially supported mean? And so what happened is Chris Hedges and Dan Ellsberg and Naomi Klein and also, what's this head from MIT? Noam Chomsky. And a bunch of folks got all together and they said, wait a second, you know, we're the kind of people that are very critical of the United States policy in the Middle East. We're constantly characterizing this as having invaded the Middle East and occupied the oil fields. Can that possibly be designated as giving any kind of, quote, support to these people? And so they filed a federal lawsuit in New York City in the federal court and said, here's a whole set of affidavits that we're putting in as the kind of things that we do and the kind of reporting that we do, which includes, upon occasion, going in and videoing Taliban people and asking them what the hell they're doing and why they think they're doing this. And what we want to know is that going to be designated under this new statute as lending support to those people? And so the judge, Catherine Forrest, an Obama-appointed federal judge, said, look, this ought to be pretty easy to handle. Just have the United States Attorney, who's here from the Southern District of New York, come on the record and say, no, that stuff would not be covered. The problem was that the United States Attorney said, I'm not going to say that. I'm not going to acknowledge that that would not be covered. At which point, Judge Forrest said, that's it. This is unconstitutional. This is potentially threatening and chilling simple news reporters that might be covering the war. And so she declared it to be unconstitutional, at which point the Obama Justice Department took it up on appeal and got it overturned by the Second Circuit Court of Appeals and got it declared that they removed the ruling that it was unconstitutional. And so now it's back in operation again. And so what happened is in February, within the year where all that pushing and shoving was going on, between January 1st of 2012, between then and February of 2013, that whole year this had been going on, and finally when there was a resolution by the Second Circuit Court of Appeals designating this as still constitutional and still operational in the country, what happened is that the California State Assembly passed a statute by 71 to 1, making it a crime in the state of California for any federal military official or other federal agent or anyone affiliated with any such federal agency to come into the state of California and to attempt to enforce this statute. Okay? And they also made it a crime for any employee or law enforcement officer in the city of California, or in California, in the whole state, to participate in any way in cooperating with them. Okay? And so you say to yourself, whoa, there it is, that's pretty strong. But in the midst of that statute, which was, for your information, it was Assembly Bill 351. Always remember that, because you can just say, if anybody says, oh, you can't just pass a statute opposing the federal government's policies on this stuff. Well, we'll say we have. The State Assembly passed it 71 to 1. Assembly Bill 351, and in that section, in addition to making it a crime for anybody to come in to try to enforce it, they had this more general statement introducing it. It says, it shall be the policy of this state to refuse to provide material support for or to participate in any way with the implementation of these sections. Okay? And so they said that it's our policy that it's unconstitutional, and we're not going to abide by this. And then they went on to say, therefore, any officer, agent, or employee of the United States government, or any employee of any corporation providing services to the United States who enforces or attempts to enforce Section 1021 or 1022 of the National Defense Authorization Act of 2012 shall be deemed guilty of a misdemeanor crime and subject to imprisonment for 1 year. And then it says that any public official or employee of the state who enforces or attempts to enforce Section 101 or 102 or in any way to assist in participating in it shall be guilty of a misdemeanor subject to imprisonment for 6 months. Okay? So what we've got here is a kind of a soft introduction in the State Assembly bill saying there shall be our policy in the state that this is unconstitutional and we will not cooperate with it in any way. they go on to make it criminal to do so. But with the more conservative Senate of the state of California, the state Senate, what they wanted to do, they wanted to be able to get a bill that they could get a unanimous vote in support of. And so they watered it down and just took the opening statement, saying that it should be the policy of the state of California that this is unconstitutional and it shall not be cooperated with, and it's our policy that no official in the state can cooperate in helping to participate in enforcing it. But they didn't make it criminal. They didn't put any teeth in it. But then they passed that particular Senate bill by 37-0. So they got the 37 of the whole total number of people that voted in the United States, in the Senate of California, all agreed that they declared it to be unconstitutional. They declared that it should be the policy to refuse to cooperate with it and to not participate in it in any way, but they removed the criminal sanctions. So what we're proposing that we do is that we establish, now we'd originally talked about potentially having the city reimpose criminal sanctions, to have it be a crime, a violation of a city ordinance, for any federal official to come in and try to enforce this, and for any state official to try to cooperate with them. Basically to replicate what the state assembly had approved by a vote of 71-2, you know? And so we were contemplating, or 71-1. I'm sorry, I wanted to give them more support than they had. But people said, look, let's try to get something that we can be sure to get a majority of people in our city to support, and potentially be able to get the people on the city council to support, so that we will first go to the city council and attempt to get them to approve this. And if they don't, then we'll do an analysis to determine whether or not there's some sort of a resolution that we can try to get the people to initiate some type of referendum to be able to force them to vote for this and to support this. Okay, sort of like a statewide referendum that we have. Okay, so what we did is we said, okay, let's do it this way. There can be little question whatsoever that the statute, even is passed by the Senate in the state, declares it to be unconstitutional, declares that it shall be the policy of our state not to allow any of our law enforcement people or any of our employees to cooperate with this. So why don't we attempt to make that effective? So what we proposed in the resolution is that the resolution would be a city ordinance in the city of Santa Cruz, stating that it shall be a condition of their continued future employment for any employee or law enforcement officer for the city of Santa Cruz, that if in fact they receive any information whatsoever or any form of contact from any federal agency or any corporation working with a federal agency or any other type of person that suggests that there's going to be an attempt to enforce this particular provision, these two provisions, 1021 and 1022, if any effort is going to be made to do that, that law enforcement officer or employee of the city is obligated as a condition of his or her future employment by the city to simply contact each member of the city council and notify them that having received such contact, and that they're obliged as a condition of their future employment to make every effort possible to solicit from the person who contacts them what their name is, what their official position is, who it is that's attempting to enforce this particular statute, who are they attempting to target, what are they planning to do, when are they planning to do it, etc., so that that information can be provided by that city employee to the city council. That's all that part does. But there's an additional part of the ordinance saying that upon receipt of such information, each member of the city council of Santa Cruz will be obliged, pursuant to this new ordinance, to immediately go to the chambers of the city council and gather together the other members of the city council. And as soon as there's a quorum, a legal quorum authorized to conduct business, to undertake a proceeding to assure the provision of the due process of law to any person who is being targeted by such an attempted enforcement. And what we propose in the statute, in the proposed ordinance, is that what the city council do is when they've ascertained the identity of the person, that they go to the person, they provide to them immediate protective custody, and that they bring them to a magistrate here in the city, and that they then hold a procedure. While that person is in protective custody, they contact federal authorities, federal law enforcement authorities, not military authorities, but law enforcement authorities, and notify them that the person is here under protective custody, and that if in fact the federal government has any information or evidence that would constitute probable cause to believe that this person has committed any crime, that they're given a time and place at which to come and present that information and evidence, which is completely consistent with the absolute minimal requirements of the due process of law. That's been decided in 100 different cases in the history of our country. And that if in fact the government comes and produces that information, then the standard that is going to be applied is probable cause to believe that they've committed a crime. Not in fact any grounds on the basis of which a suspicion has been developed on the part of the executive branch that this person may have provided significant support to some person who had in turn provided some significant support to some organization that is an affiliate of one of the organizations that has been designated by the federal government as having harbored hostile intentions toward the United States or one of its allies. You know, like starting off by saying, which ally are we talking about here? Okay, and what was the support that was provided? You know, to whom was it provided? What kind of support are we talking about? Because what they've done is they've removed from this statute, the section 1021 and 1022, they have removed the requirement that is in all other federal criminal statutes that the person has to have provided substantial material support. And it's an element of the crime of a conspiracy to commit any kind of an act of violence, that a person has to provide some sort of material support, so that there's something other than a First Amendment expression or a discussion of some kind that has been had. Okay, because the fundamental challenge of this entire statutory scheme is that it has such a dramatic and obvious impact upon chilling any type of First Amendment activity, of discussing the policies of the United States government, criticizing the policies, discussing, you know, the reasonableness of whatever positions are being taken by anybody in the Middle East to try to get them out of from occupying their oil fields, etc. You know, so that what we're doing is this statute is insisting that the city of Santa Cruz will provide simple due process to any person that is being targeted by the federal government, rather than allow the military to sweep in here and bag the person like a classic rendition and take them off to a military prison where they can be subjected to enhanced interrogation. That's the whole point of bringing them to a military facility. That they are not provided any of the rights that would attach to your being held in federal custody in any kind of a legal institution. Okay, so that's what the purpose of this whole thing is, and the objective is to have it be similar to what we did, and we talked about this even just yesterday, similar to what we did with regard to the nuclear-free zone. That when we won the Karen Soulwood case back in July of 1979, we had to fly immediately from there to go to 3 Mile Island, because we also represented the people of 3 Mile Island. And we were successful in getting the court order to stop the pumping of the radioactive effluents into the Susquehanna River, because the Nuclear Regulatory Commission had already authorized them to dump all the water into the river. And we proved that it was completely filled with radioactive nuclides because they had a partial meltdown, which the NRC had denied. Okay, so So that right after we did that, what happened is we said that, look, we've got a statute, or we've got a federal decision now that has declared unconstitutional the financial cap that had been imposed by Congress in the Price-Anderson Act, setting the maximum of $10 million as the maximum financial judgment that could be entered by any civil jury against a private nuclear facility for releasing radioactive materials into the community, from anything from a massive leak to an explosion, blowing up and contaminating an entire third of a state. You know, they had set a maximum of $10 million as the maximum judgment that could be entered against them, because the petroleum companies that owned most of the nuclear power plants, or wanted to build them, they bribed the Congress people by giving them massive contributions to their campaigns to get them to limit their liability in order to stimulate the private development of nuclear power in the United States. And what we said in the Silver case is that's unconstitutional. You can't pass a statute like that depriving a person of their Sixth Amendment right to a jury trial and to have a reasonable judgment imposed upon someone that actually covers your damages and actually deters future conduct like that. You know, that's the classic common law that's been around for like, 400 years. And so we succeeded in getting it declared unconstitutional. And we won a judgment of $10.5 million against the Carnegie Nuclear Corporation on behalf of Karen Sopan's children. And because of that, as Sarah mentioned to you, that not a single new private nuclear power plant has been ordered in the United States since the day of that decision. And what happened then, of course, is that the private nuclear industry went berserk, and they said, and we talked about this yesterday, the folks over there, what they said is, well, what we're going to have to do then is we're going to have to, dig up all of the radioactive waste materials that we buried on these 103 private nuclear facilities all across the country, and then ship it across country in trucks and on trains to Yucca Mountain, and bury it under Yucca Mountain, which just happened to be over the major aquifer in the southwest United States. But that's what they were planning to do. And so what we did is we mobilized and we went from city to city, talking to the city councils, telling them what it is they were planning to do, explaining to them the kind of completely irresponsible containers that they were going to put this radioactive material in, so that if it fell off a truck or the train wreck, it was going to break open and contaminate the entire city and area. So what we did is we got one city after another to pass a resolution declaring their cities and then their counties to be nuclear-free zones. One of which, of course, was Santa Cruz. So what we said is, look, let's do something similar to this. And so what happened is the city of Santa Cruz actually passed an ordinance declaring that they felt that this statute was unconstitutional, and that they thought that Sam Farr ought to introduce a bill trying to get it revoked. He said, well, great, fine, as far as that goes. What good does that do? Just saying, oh, we think it's unconstitutional and Sam Farr ought to do something about it. What we said is, like, you can do more than that. And so that's what we're in the process of attempting to get done right now. And the fact is that the resolution that was passed by the city council was introduced by Don Lane and was seconded by Ryan Coonerty and Catherine Byers when she was on the council. So there's support for a kind of milquetoasty kind of resolution here already, and we've got a state assembly bill 71 to 1, threatening to threatening to put them in jail if they try to do it. And so what we're saying is, look, we're not demanding you put them in jail or try to arrest them or send the city police armed against the military of the United States. What we're doing is just saying, don't just say, oh, you ought not to cooperate. The military doesn't need our cooperation. The problem is they need to be stopped. They need to be blocked. And we're not talking about taking up arms against the government of the United States. We're talking about taking into custody the person who's targeted and protecting you.
Right.
In the same way that Jerry Brown protected Dennis Banks back in 1973 during the occupation at Wounded Knee. I happen to have known about that because, as Sarah mentioned, I was legal counsel for the American Civil Liberties Union at Wounded Knee and doing the amicus work with some other people, and we knew exactly what happened. So we know that Jerry Brown has in the past refused to allow federal officials to come and arrest people in the state of California for acts which he deemed to be politically motivated, on the part of the federal government, in that case the Nixon administration. So that we have plenty of precedent for this. But the fact of the matter is, you start out number one, is that 99% of the people don't know that this statute has been passed. And the fact is that even when you tell them, they don't believe it. They don't believe it because it can't possibly be true. How could anybody possibly do something like that? And so what you have to do first is it's very difficult just to walk up to people on the street corner and start trying to talk to them. We've tried, we had Garrison Keeler was here coming to the Civic Auditorium. You're trying to get people and explain this to them, within 10 feet of their getting to the ticket booth, and you don't have time to do that. So that we have to set up a campaign, probably going door to door and talking to people and going to places where we get people to come to meetings and things like that. We had Chris Hedges come and have an event over at the church. That there are various tactics that we need to undertake, but this has been known by people usually in the religious communities, historically, of what type of tactics you have to engage in to try to stop draconian activities. And it dates all the way back to the White Rose in Germany. When the government moved step by step by step to try to make legal every single thing that Hitler and the brown shirts wanted to do. And the fact of the matter is that they passed statutes authorizing them to take all the property from the Jewish people. They passed statutes, authorizing them to arrest all the gypsies and stuff. The famous Niemöller quote. That when they came to get the Jews, I wasn't a Jew, so I didn't do anything about it. And then they came to get the communists, and I wasn't a communist, so I didn't do anything about it. And they came to get the socialists, and I wasn't a socialist, so I didn't do anything about it. And then they came to get me, and there wasn't anybody left to help. That's what we're looking at here. What we're looking at is the combined right wing of the Republican Party, the spineless conservatives in the Republican Party, not wanting to be characterized as soft on terrorism, the equally soft-spined, blue dog Democrats, the new, more moderate Democratic Party of Richard Gebhardt in the Democratic Leadership Conference, the chairman of the policy committee of which was Hillary Clinton, and Bill Clinton. These type of, if you will, mealy-mouthed, middle moderate type Democrats are terrified of being characterized as soft on terrorism, just as they were terrorized about being soft on communism. The whole thing that we experienced during the McCarthy era. We're having a replay of that exact same thing. And the fact of the matter is, you have to nip this in the bud as soon as it starts. And this thing has gone across the line now. And there's no reason why people in the city of Santa Cruz need to tolerate this. Because the people in the right wing of the Republican Party and the mealy-mouthed, middle marginalist Democrats are just looking to see if we care enough about this.
That's right.
Because if we don't, John Yoo, who actually wrote a number of the legal briefs authorizing torture, under the W. Bush administration, has written a whole book on the National Security Constitution. He's argued that the passivity of the people in the face of an executive branch action taken unilaterally, the passivity of the people in the face of such a thing is a common law authorization of that act.
That it's considered.
He's written it out. So it isn't as though we don't know what these people are saying. Okay? So our acquiescence in the face of knowing about this is being taken as direct evidence of our ratification of these kind of actions.
And it shouldn't be surprising, because what's happened, what we saw happen, is W. Bush gets caught wiretapping all the telephone conversations in the country, monitoring people's not only telephone calls, cell calls, computer communications, etc. And what's the Congress do? The Congress rises up, and passes a statute authorizing them to do it. But you only get to do it under these certain circumstances. And that's exactly what's happening. Because the people in the Congress are being bribed by the major right-wing organizations, the Koch brothers, etc., to support these kinds of activities. The fact of the matter is, if the people of Santa Cruz can't rise up and stop this, then it is a very bad sign for our country. But the contrary is that once the people of Santa Cruz do rise up and do something about it, it's a very good sign for our country. And then it can start, county by county, across the state. And once California comes on board stopping this, then we then move to the other congressional districts around the country that are part of the Progressive Caucus. There are 63 Congress people that in fact come from cities and congressional districts where they have universities where they actually read books, and they actually think about the Constitution. They actually have discussions. They actually come to meetings on Sunday morning, to talk about things like this. And so that we have to set an example for the people of the country, that we have to show them that, what is it? Are we afraid to go knock on the door of a neighbor in this city and say, look, I want to have a conversation with you about this statute that's been passed and signed by the Obama administration. I know that you're not going to believe that it's true to start with, because I didn't believe it when I first heard about it. But I want you to see this. We're not Seventh-day Adventists trying to get you to join our church. We're not harassing you. We're trying to share information as an American citizen with you, and we want you to come to understand this. And what we have to do, each and every one of us in this small group, we have to be able to overcome that twinge, that kind of, this could be embarrassing. They could say no. They could say, get off my front porch. They could call you a communist. They could call you a terrorist lover. They could, oh, gee, that's too fucking bad if somebody does that to you. If we aren't willing to be able to endure that type of potential conceivable response, then we're selling out. We're in fact so afraid that we can in fact have the same kind of thing happen here in our country that happened in Germany. That people were afraid. They were afraid of being embarrassed. They were afraid of having people respond in an adverse way to them. They were afraid of being accused of not being adequately patriotic. And that's exactly how it happened. And yet people still to this day say, how could that have happened? How could that have happened? This is exactly how it happens. That feeling that you have about not wanting to be embarrassed, walking up to a neighbor's door and trying to get them to understand what's going on, that's how it happens. That's exactly how it happens. Okay? And when you start getting past that thing, it's just like getting back into shape. It's like being, here's a set of stairs. I don't know how to be stairs. You walk up the stairs. It hurts. It's hot. It makes you feel terrible. And after you've done it for a little while, you start, hey, that's not that bad. And that's what you got to do here. We got to get back into constitutional shape. We are becoming constitutionally irresponsible. So that's what this is all about. So we're here to offer you an exercise program, a 12-step program, to try to get back into shape, to try to recover from being addicted to our fear, to being addicted to our comfort levels. Because that's what these people are doing. These people have put us into a warm pot of water, and they're turning up the heat step by step. And what I'm suggesting to you is you jump out of this pot right now, because it's only going to get hotter. Because we are very familiar at the Christic Institute, and now the Romero Institute, we're very familiar with who these people are. We're very familiar with what it is that they have in mind. And you need to remember that in the Iran-Contra, so-called Iran-Contra scandal, which should have been the Iran-Contra federal criminal prosecution, you know, of like 24 of those people, they should still be in Leavenworth prison, these people. But they weren't, they were let off on the whole thing. And the special prosecutor, Lawrence Walsh, in his final report said, you as Americans are going to live to regret this day when you allowed the Democratic and Republican Party to let these people off with no substantial punishment whatsoever. Because these people are going to come back very soon, sooner than later, he said, under the rubric of anti-terrorism. That's what he said. And it's because this guy, Lieutenant Colonel Oliver North, derived, remember how they keep saying, how did a young lieutenant colonel get all of this influence and power? He was the director of anti-terrorism for the National Security Council of the Reagan-Bush administration. That's where he drew his power from. And he knew how to use it. He knew how to intimidate people about being afraid of being accused of being soft on terrorism. And this was way before 9/11. Way before 9/11. This is in 1982, 83, 84. You know? I mean, you know, this is years and years before this alleged caliphate, you know, that of this this extreme, ultra-conservative, fundamentalist Islamic caliphate wanting to take over the world. You know? That's our job. Taking over the world. You know, that's exactly what George Carlin used to say. Who are these people trying to take over the world? That's our job. You know? And that's exactly what we're looking at. We're looking directly at that because this is the group of people that at the end of the Cold War in 1992, or December 31st of 1991, again, 10 years before 9/11. 10 years before 9/11. Immediately upon the voluntary dissolution of the Soviet Union, came back into the Oval Office on the following Monday morning with Paul Wolfowitz, all working for Dick Cheney as the Defense Secretary under George H.W. Bush, and crafted the 1992 United States Defense Department Policy Planning Guidance document, calling not to start reducing military funding because the Soviet Union had dissolved itself. Not talking about dissolving the Central Intelligence Agency that had been created by the National Security Act of 1947 specifically to offset communist aggression around the world. Now that the Soviet Union was completely dissolved, not recommending that we reduce the military budget, proposing that we increase the military budget to take advantage of this unique moment in history so that we could establish full spectrum dominance over the planet. That's their term, full spectrum dominance over the planet. So that nowhere on the face of the planet could any force arise that could withstand the unilateral application of U.S. military power. You know, nobody has to be a rocket scientist to recognize what that is. That's exactly the agenda that was had by the Third Reich. Okay? And it shouldn't come as any surprise, because the Third Reich was funded by George Herbert Walker, who was the grandfather of George Herbert Walker Bush. Is the chairman of the Brown Brothers and Harriman through the Union Bank of New York that funded the purchase of the national headquarters for the fascist party in Germany. I mean, it doesn't take rocket science to know what's going on around here. Okay? So I'm suggesting that you become the White Rose. That we have to stand up. The White Rose rose in Germany to oppose what was happening, but it rose up too late. It rose up too late because there were a whole series of anti-terrorist pieces of legislation in power by the time they got mobilized that authorized the brown shirts and people to swoop in and tear down their offices if they so much as spoke out against the policies of the government. Okay? And that's exactly what's getting ready to happen here. And they're doing it now against so-called eco-terrorists. That's right. They're sending anti-terrorist agents from the FBI into the universities and libraries after people who, in fact, are raising questions about fracking. That's because what they're saying is, oh, anybody who starts raising questions about fracking could become a terrorist. Could, in fact, try to blow up their facilities and stuff like that. So we've got to get out ahead of time. We've got to engage in pre-crime. You know? This is the Minority Report. You know, they ought to bring in Tom Cruz and the Scientologists to help them. You know, I mean, this is pre-crime. This is going after people who are beginning to think about discussing opposition to government policies that could conceivably lead to them being terrorists. You know, this is what we're facing right now. Okay, and so what I'm suggesting is that you and I and everyone else need to overcome the anxiety, the kind of sense of embarrassment, the kind of discomfort level about, you know, going with a clip pad, you know, clipboard to the door of our neighbors and asking them to listen to what it is that's going on. Okay, that's all that we're asking of you. You know, we're asking about a little bit of time to come to the meetings every other Wednesday at the Romero Institute over here. And I want to leave you with an additional understanding that you don't know about, except for the people who came yesterday, is that Tuesday morning, last Tuesday morning, there was convened in Rome a major conference called by Pope Francis to discuss the connection between global climate change and transnational corporate capitalism. And he is, in fact, going to be announcing that he's going to be issuing a papal encyclical in June, declaring that transnational corporate capitalism is the proximate causation of global climate change. Yes. Calling for the establishment of an entirely new alternative economic order on the planet. And he is preparing to go before the United Nations in September, the General Assembly, calling for the dissolution of all debt on the planet. Calling for a Jubilee year out of the ancient Jewish tradition of the Bible, declaring all debt to be alleviated in the world, leaving the banks holding the bag that they should have been bagged in back in 2008 when they did it before. All 1.5 billion Catholics in the world to refuse to pay the debts demanded by these banks. And to let them eat it and have to sell off some of their yachts and additional properties that they all got since 2008 by getting the billions and billions and billions of dollars of U.S. tax money given to them, because they were all going to take their chips and go home. You know, if we didn't give them that. So what I'm saying is that you need to understand that there's getting set to be declared a major Jubilee year. There's getting set to be declared a specific recognition of the direct connection between transnational corporate capitalism and the global climate change that is threatening everyone in the world. And you better believe how terrified that is going to make the people in charge of the Republican and Democratic Party in the country. Yes, and that they're going to view anybody who gets on board attempting to carve into their power as potential terrorists, because they know that that's exactly what they would do if they were in our position. That they would take up arms, they would become violent against the government if in fact what we see them doing to us was being done to them. And we're going to be able to show them that we can do it without violence. We can do it through discussions, we can do it through organizing, we can do it through conscientizing. And the problem is they're going to identify that as pre-crime.
That's right.
That's getting ready to work your way all the way to doing what it is they think you ought to do. If you really are going to take steps to effectively stop them, they think we have to go to violence. I'm telling you we don't have to. I'm telling you that we can mobilize, we have time to mobilize, we still have access to adequate constitutional principles to mobilize, and we are going to be organizing the lawyers to help protect people on this and fight through the courts as is necessary. But we're not going to be depending upon the courts to support us, because we've been through that before, back in the 70s. You know, with the Chicago 7 trials and everything else. The judges, you know, like 80% of the judges were appointed by these people. You know, by Richard Nixon, by Ford, you know, by Ronald Reagan or H.W. Bush or W. Bush. These people are constitutional criminals. You know, these people wouldn't, you know, these people think the Constitution is a ship that sits in the harbor in Boston. You know, I mean, and they don't care about the constitutional rights. They're openly hostile to these constitutional rights. So we're going to stand up and fight for our constitutional rights, but we have to overcome our discomfort Okay, we have to overcome our discomfort. And we have to be willing to understand that there will be a tiny percentage of people who tell us to get off their porch, that call us soft on terrorism, whatever it is they want to say. We have to be willing to suffer that type of discomfort in order to save our country, in order to save our Constitution, in order to save our planet, to be able to save our human family from these people. Because these people have not gone away. These people have merely stepped back from World War II and are still on the march.
That's right.
And they have to be stopped. Okay? And that we're the people that can stop them because we are the White Rose.
Yes.
Okay.